Ladies and gentlemen, so that the record is clear, what our plan is that the attorneys and the court, we're going to go through all of the exhibits after lunch to discuss what items that are allowed in or not, so that you're aware. Just because something has been marked as an exhibit doesn't mean that the jury necessarily gets it. We wait until the court makes a determination whether it's going to be allowed in. So that's what's going to happen this afternoon, and we're also going to go over the jury charge again in anticipation of summations next week at some point. So with that being said, that'll be at 1:30. It's an open courtroom. If you want to be here, you can be here. If not, there will be no testimony this afternoon. It will just be going through the physical evidence and also going through the jury charge. All right? Just want everybody to know that. All right, I'll see everyone back here at 1:30.
Nah, just for the record.
Back in session. The Honorable Judge Mark Lemieux presiding.
All right, we're outside the presence of the jury. We're back on the record. State of New Jersey versus Paul Caneiro. It's indictment 19-02-0283. We have all the attorneys present. We also have the defendant present. I had asked the attorneys to go through the exhibit list for both the state and for the defense to at least be in a position so that you can tell the court what objections there are. We will argue those objections now, and then what we'll do is, after the defense rests, whenever that may be, at that point in time, I will formally move in the evidence so that it can be considered by the jury. So let's start from the beginning. At the top, from the prosecutor's office. I'm not sure who's going to be handling this, but let's start with the photo book. Tell me where we are. Tell me the ones that we are moving without objection, and if we're not moving them, the process that you're going to go about so that the record is clear. I see Ms. Wallace standing up. So the process of what you're going to, how you're going to go about blocking out pictures that you did not use so that we don't have any issues in front of the jury.
Thank you, Judge. We'll be moving S1, A through I. However, there are several pictures that we do not use that we would black out that I have listed.
Okay. I mean, have you gone through with the defense? Are both of you in agreement as to which photos are in and which photos are going to be blacked out?
I don't know that we went through those. I'm sorry.
What have we been doing?
So, Judge, if I could, before we broke for lunch, my understanding is that the court wanted the parties to organize their evidence and decide what each party wanted to move into evidence. So that's how the defense spent the lunch break. We went through all of our photos. We organized them so they'd be in order for the court and for the state to review so that they would be organized. We looked at our documented exhibits that we had. We decided, yes, we want things in or what have you. So that took the hour and a half or however long we had during the lunch break. Then when we came to court at 1:30, we were under the impression that at that time you wanted us to confer. So we had a copy of the state's updated exhibit list, but we didn't have access to their exhibits. So we weren't, it was kind of out of context, like an email dated. We needed to actually be able to compare from the item in the exhibit list to what the item actually is as far as whether or not we had an objection. So we just spent the last hour and a half, once the court gave us access to those exhibits, we were able to categorize these items as far as either no objection or we do have an objection or we're reserving because we're just not sure. I think some of this has to maybe even be researched as to whether or not it's admissible. So that's where we are. We can let the court know certainly what things on their exhibit list we do not have objections to, or that we do have objections to, or that we are uncertain of at this time, but we can certainly let the court know and the state know early next week. Also, we did not have an opportunity to look at the photo book and see. I mean, I can represent that generally speaking, we don't have an objection, but perhaps once the state has the opportunity to black out the photos and has like the final photo book that they're gonna present to the jury, we can just flip through it and let the court know if there's one or two photos that we have an objection to.
All right. So I'm not sure how the miscommunication happened, because I had indicated that I wanted you guys not only look through your stuff, but also to discuss what objections that there would be. That's fine. We're here and we are where we are. So obviously, let me just say this. The items that have been testified to, that have been on that screen, there was no objection for those items to be placed on the screen. So I would have difficulty, so the defense is aware, to not allow in photographs that the jurors have already seen. Foundations have been laid. Any photo that has not been shown is automatically out. So that's not even going to be an issue. And the way that I would suggest doing that is, how many are we going to do on a page for purposes of the jury book for the jurors?
For the jurors, it's going to be one per page.
So one per page. So if you're going to do that, then my suggestion would be is that you can just do them in chronological order. Just take out the ones that were never shown to anyone. I have my book also. I tried to write down that like everyone has here, which I thought was great. Good job. But I did the exact same thing to make sure that I have my own notes as to what picture was showed to whom. So I'll have that. So once you have that book, if you want to, over the weekend, I want you guys to talk over the weekend and look at the photo book, show it to each other. If there's any issues, that Monday when you come back, that we don't have to spend time, that it's just for you to take a look at it. And at that point in time, let me know if some picture you're saying was not shown to a particular witness, so you would have an objection to it, or if every picture was shown, you're going to have to prove to me why that now, after it's already been published, it's already been shown by a witness and its foundations have been laid, that I wouldn't allow that to be in. So I say that to you just as a background, so you know, for purposes of pictures I'm only talking about right now, that's it. That would be the court's request. That's going to be my ask of you. So you guys could take that advisement and instruction, and we'll talk about that on Monday. I won't touch the book for now. I recognize there's a lot of pictures, but a lot of this stuff I think should be pretty straightforward once you've had the opportunity to look at it. All right, so let's put that aside as to S1. Okay. What's your next item that you're attempting to move?
S2, Judge.
Okay. Is there any objection to that? I was shown today. Okay. So that will be in evidence. Next.
S7.
No objection.
Next.
S8.
No objection.
Okay.
No objection.
Okay.
S11.
No objection.
Okay.
S12.
No objection.
Okay.
S12 included some sub numbers.
Yeah, 1.1.2.3, people marking it up. Any objections to the marked up photos, Ms. Messalone?
I don't believe so, Judge.
You should have copies of those. I'm assuming Anna gave everyone. You have it? Okay, good. So for the record purposes, when I accept these, it would be not just S12, but S12.1, .2, .3, .4, and .5 will all be in. Okay, next. 17, I'm sorry? Okay, yeah.
No objection.
All right.
S18? No objection. S19, A, B, and C? No objection.
All three, okay.
S26? I just skipped one. S25?
That we do have an objection to.
The actual report?
Yes.
Why would you move the report in?
Which we won't, he can withdraw that, we won't
Okay.
report it.
Yeah, that's not in evidence. His testimony is what's I will allow, not the expert report. 26 was next?
Yeah, S26.
Okay.
Sorry.
No objection.
Okay.
S28.
No objections.
Okay.
And then S29.1 through 10.
So, okay. I think I understand.
We had a question mark on that, Judge. If we can, it looks like it's a lot of the point exhibits. If we could just maybe.
Yeah, those were the ones that she either wrote on or there's circles on. That would be what was printed out here. She testified to it, and then we would mark them that way. So that's what we're talking about.
Okay, so the S29 itself is not coming in.
Yeah, S29 would be the bank statements 3837 from 2017.
So the full year of statements then. I mean, the thing is, if that's the way this is going to go, I think it's important just to note that there were not the entirety of those bank records was testified to.
I agree.
In fact, Detective Bassinger said she specifically didn't review or didn't document certain areas.
I agree with you.
And if the state wanted to put in the full record, I would just note that, well, one, I think it would have to be heavily redacted, but two, it would prompt us to respond to certain, requests of the court to introduce certain items that we hadn't previously contemplated, but that were discussed with the witnesses. So I don't know how the court would want to handle that. I think just at the outset, we would probably raise an objection to the entirety of the statement.
Okay, but you don't have an objection to 1 through 10 because obviously something was circled on them or something happened with those.
They were
correct?
marked, they were shown to the jury. That I think that's a different issue. They were essentially used in the presentation, so I don't think we have a basis to object on that.
I respect what you're saying. Ms. Wallace, my issue is, and tell me what the testimony is and I'll take a look at it, but I don't recall the entirety of that exhibit being shown. And there may be other things in that packet that may have an issue to it or some hearsay information in it or something else that I'm not aware of. I don't know. I don't have it in front of me. But is it that you need 1 through 10 or do you need the entire document?
Well, these documents, so 3837, 2017, and 18, these were the bank statements that Detective Bassinger relied on to write her summary charts.
Okay.
These are all of the defendants. I showed them to her, we marked them, and even though we went through them and she circled the areas where there were withdrawals being made from, well, I guess it would be incoming money from the trust account into those accounts, I highlighted different areas where perhaps his balance was negative or whatnot. We didn't circle those, but we talked about those areas. So I had provided her the whole document. I wasn't planning on moving like certain other bank records in, but these were pertinent ones for 2017 and 18. They were the defendant's main bank account.
Here's what I'm going to say to you. Why don't you take a look at the document, speak to Mr. Murray about it. If there's certain areas that were testified, but always remember that the testimony is still there. It's in evidence. So it's still fair comment. And you do have these ones that you marked. So take a look at that over the weekend, discuss it between the two of you. If you come up with an agreement, fine. If not, I tend to agree with Mr. Murray on this, that I don't know if the entire document should be coming in. So let's just take a look at it.
Sure, we'll do.
Okay, so we'll come back to it. But point 1 through point 10, I have no issue with.
And then I think we have S30.
And you have point 1 through...
Yeah, it's a 2018 one, so I guess the same issue.
Same issue. So I have no problems with point 1 through point 19. Mr. Murray, I assume you don't on those. It's just the entire document again, right?
That would be right, Judge.
Okay, so let's take a look at that. Okay, next.
Next one that we had, I think there would probably be the same issues with these, because these are the bank accounts, S33 and S34, S35 and S36. Those are the remaining bank accounts that we looked at of the defendants, but I think there were points marked, so like S33.1, 34.1.
yeah.
So I think it's probably the same issue.
Yeah, so I have no problems with the point 1s, because we know for a fact that they were testified to, there was markings on them, so that testimony is noted, but the full records, you guys got to take a look at, and you and Mr. Murray can tell me on Monday where you want to go with that.
Sure. And then S37 and S38, they were discussed, they were the TD Trust Bank account statements. I don't think we marked anything on them though.
No. So same thing, the testimony's there. I'm not sure that I would let it all in, because I'm not sure it's all in there, but you guys can take a look at it over the weekend, and we'll revisit 36, 37, 38.
Okay.
So actually it'll be 33 through 38 that we will revisit, including going back number 29 and 30 we'll revisit. You guys can let me know.
Okay, we'll do. And then we've marked S39, but that's an expert report, and it sounds like we're not moving those, so. S40 would be actually report, just A and B, so that would be the charts that we use, the summary charts of the poster boards.
Yeah, so when we looked at S40, just so the court's aware, when we looked at the actual S40 exhibit, it did contain a portion of the detective's report, separate and apart from the charts. We don't have any objection if it's just the charts.
Okay. I agree, there's no issues with the charts, they should come in. But I'll just ask you to redact a portion of the actual report. Obviously, she testified to her report, so that's fair game for summation.
And then S42.
Any issue with that?
Well, I mean, I think that we just had a question about in the state, they can, I don't know if this is their perspective on it or not, but, for example, as far as S44 and 45, the annual policy statements, like we don't have any problem with documents like that coming in. They were testified to. They're fairly straightforward. They show the policy is active in those years. They show where the records are going. They show who the insured is, right? So we don't have any issue with that. But the whole life policy of Keith Caneiro, that 19-page document, I don't know if the entirety of that was really the subject of the exam.
There's a lot of areas that were referred to both on direct and cross.
There were. And
should we give it to him for full context so it's understandable, or what are you proposing?
Well, I certainly don't have an issue if it is, I'm not saying that anything that was discussed obviously can be brought up
Right.
on summation, during summation.
Yeah.
And I would just say this, I guess our stronger, to the extent we have an objection here, our stronger objection is really S43. So, I guess what we could say.
Can we just reserve,
Yeah.
Judge, and talk about it? Can we meet and confirm? Because this was in our category of we're unsure.
42 and 43?
Yeah.
Yes.
But you're okay with 44 and 45?
Yeah.
All right. So 44 and 45 are good to go. 42 and 43, why don't you take a look at, Ms. Wallace, you can let me know also, because I definitely recall there was a lot of areas that were being referred to back and forth. So there may be something that you guys can agree to as to the areas
Okay.
that were testified to, because you read them into the record, so just let me know.
Okay. I think we're at S44 here.
Well, 44 and 45 were good. There's no issue, but Mr. Murray said there was no issue there.
Okay. S46,
Okay, no objection there.
S47,
No objection.
S48,
No objection.
S49,
No objection.
S50,
No objection.
S51,
No objection.
S52,
No objection.
S53,
No objection.
S62.
I need to go back for a second. The S52. I'm going to go to the trusted paralegals over in the corner. Are we sure that
I'm sorry.
we didn't? I don't think that was shown.
Okay, then, that was highlighted, I inadvertently then read it. If it wasn't shown, then.
Okay, so then 52 is not going in. Okay. I'll look back through my notes and see if I find it. But I'm sure that they have it. I'm not seeing it, so we'll just take another look. Both sides take a look.
It's in the Canada Life payment history, which was an exhibit that is going to be in evidence.
Oh, I do have it. On January 13th, it was marked. So we're okay. January 13th. So it's two, so that'll be in evidence. 52 is okay.
We have S53.
I think there was no objection to that already. Am I correct, Ms. Messalon?
We don't believe so. We think that was the history of the invoices on policy.
That's exactly what it is. Yeah. So no issue there, right?
No.
Okay. Next.
S61 is just A and D, which would be the photos of the defendant's phone from Detective Nicolaisi's report, and then photos of the Wise cameras from his report.
No objection.
Okay.
S62.
So we do have an objection to S62 through S65. These are the text messages or these are the text messages that Detective Miglorisi read into the record. They were shown on the screen, and then he would indicate like what each message stated. The problem is if the court may recall that like there's the messages themselves are not dated or time-stamped, and the state had printed each message individually on a page and stacked it together. We have concerns that it's not like a normal extraction report where it's organized and you can follow along. So we have concerns that if it's in the hands of the jury, it could easily get like disorganized and there's no way to put it back together. And also, I think that the testimony was sufficient, and I think if they wanted to know, if they had any concerns about it, they could also always either recall the testimony or ask for a readback. I have concerns about the formatting of those specific messages. It's just like a blank piece of paper with words on it. It doesn't say who it's from, it doesn't say who it's to, it doesn't say, or maybe it doesn't have the date or the time. It's not like in a pre-organized fashion.
Can I see those on the screen?
Some of them might have not all of them, I think. And then the other issue, Judge, is we would also just maintain that objection to the first couple messages that dealt with divorce and not knowing where he was going to live. That was in April of 2018, not November. So, we would say that it's irrelevant, or object to relevance and prejudicial.
Okay, so this first one was from Keith, and it was testified to here that this is Keith forwarding to Corey.
Right, it doesn't say that though on this.
There was testimony.
Yeah, there was testimony that said who it was to. Okay, let me see the next one. Same thing, and it says from Keith Caneiro. It was testified to that it was to Corey Caneiro. Next. Same thing, it says from Keith Caneiro, and it was testified to Corey. Same thing for the next one, that's the fourth page. And the same thing with the last one from Keith, that was testified to Corey. So that's S62. So these are the text messages.
I think these are emails.
These are, they were in that the Google Hangout section, so they're a mixture, I think, of emails and texts. And I would just note there's 4 batches.
We'll just call them messages. Yeah, sorry.
That's okay. There's 4 batches of them, and we put on the record each time he would testify to a batch. It was April 11th, September 13th, September 17th, and then the final ones are from 11/5/18. And Judge, I would just note they all do say who they're from.
Right. Okay. Let me see 63. For a minute. So the first one just says, did you talk to the Terminex people? And then the next one says, was testified that that's Paul's phone number. Yes, they're not budging. So your position with this, number one, even though it's documented, Ms. Messalone, even though that it's documented on the exhibit list, it's not noted anywhere on the exhibit as to the date when this happened, even though that I'm assuming the extraction report says that, but it's not attached to this. Is that a part of the argument?
There is no extraction report that is associated with these messages. They're not taken from a cell phone, they're taken from the Google Cloud. So that's exactly the issue, is if they were associated with an extraction report, I would feel more comfortable with the jurors having organized information. If they were to drop the messages on the floor, they can't, there's no way to put them back together. They're not dated, they're not time-stamped. I think that it would be prejudicial to have them handling this type of uninformed information. I think they heard the evidence, and I also think it's pretty. These messages were subject to the to the pretrial litigation motion. So I think that there is an aspect that these are a certain level of prejudicial. Perhaps the relevance or was outweighed the prejudicial value, which is why the court ruled it. And it was admitted at trial. It was read out loud to the jury. I think it was
I got you. I heard you. I was just asking a specific question. All right, I'm gonna reserve. I'm gonna look at these.
Can I just supplement too?
Yeah, of course.
There is an index that was provided. I understand that the argument is that the jury doesn't have them, but there is an index where it has all of the dates listed. The defense sat with us over the summer at that time, and Detective McLarisi downloaded this onto their computer. They were able to view it. So there are dates. It's not that there aren't. It's just, I understand the argument that there's not necessarily dates on the page, but they were testified to.
No, I get it. The issue is that it's been testified to for these dates, but there's nothing from, if they go back and just take the document, there's nothing that puts the September 13th date on it, other than the testimony. So let me just think about it. But I understand the objections, and I will render that decision on Monday.
Okay.
So that's 62 to 65.
66 would be next, A and B.
No objection.
S69.
No objection.
S70. S74 would be A through D, and then there's a B.1.
No objection.
All right, so it was 69. Sorry, you guys went a little quick. 70, you said?
Yes.
And then 74?
Yes, and that would be A through D, and then on 74 there's also the D.1.
Right, and there's no objection to that one. Okay, next.
S76, A through D.
No objection.
Okay. Then
S78,
No objection.
S93,
No objection.
okay.
S94,
No objection.
S96, that would be B.
We don't have an objection to B. What we wanted to do was, I'm not sure if maybe the entirety of both clips should be admitted, and for context, I'm assuming they were both played.
I don't think did we think Forrest is...
No, one of the calls didn't
We
play.
didn't.
They said 911, what's the emergency, and nothing. We didn't play it.
Okay, no objection.
So it's just 96B,
Yes.
correct?
Yes.
Okay.
S99,
No objection.
S101,
No objection.
and S102 and 102.1.
No objection.
S138,
Judge, we wanted to take a look at that. I'm uncertain about that. If we could just reserve on that for the moment.
You want to put in the evidence property receipt?
I think, I think it was just for purposes of chain of custody, a document, but
Can I see 138? I think I can answer this. Ms. Massalone or Mr. Murray, is there an issue that you are going to argue as it relates to contamination of the evidence of those 4 items?
No.
No.
Okay, so if the answer to that is no, then I'm not going to allow it in. It's not necessary.
okay,
If there was an issue with it
sure.
on another evidence property receipt,
Okay.
then I would consider it for them. But if they're not, I'm not going to put it in for any other reason. Okay?
Sure. S150.
It can be talked about in your summation, but it just can't.
S155.
No
S156.
No objection.
S157.
No objection.
S158.
No objection.
159.
No objection.
160.
No objection.
161.
No objection.
162.
No objection.
163.
No objection.
164.
No objection.
165.
No objection.
166.
No objection.
168.
No objection.
169.
No objection.
170.
No objection.
171.
No objection.
172.
No objection.
173.
No No objection.
74.
That we do have an objection to based on relevance. And same with 75 as well.
Go ahead, Ms. Wallace.
Thank you, Judge. I would just note these were shown to the jury. The relevance of the savings bonds, I mean, I think it's something that he had, and what the state's position is his go bag, essentially, along with his passport and some of the other items that were listed in there. S-175, the mail that identifies him as being his backpack, the financial documents in there, etc. I think that those are relevant as well.
I understand that the objection by the defense. I do find these to be relevant, and I also find under the circumstances that under a 403 analysis, I do find that the probative value outweighs any prejudicial effect. The theory of the state in this case is that the defendant, after he allegedly committed these offenses, that he was going to take off and he was going to need money to get out of here. So included all of the information, all the items that were in this bag, to include savings bonds and to show identification of the bag. 175, I do find to be relevant. Again, under 403, I do find that the probative value outweighs any prejudicial effect. Even if there is some prejudice, it's not enough to overcome it. So I'm going to allow in 174 and 175.
Just so, as far as identifying the bag, 172 with his bank card and things of that nature, his passport, obviously that makes sense. The concern with is also like the hearsay of the mail. I don't know what mail this is. I have no idea who it's from, who it's to. I don't know, is it open? Is it, like, what's the mail? Is that, why does that?
It's in a bag that's actually it's secured and fastened, so I don't expect anyone to be going through the mail or manipulating a piece, but go ahead.
No, it's just for the idea that he had all this stuff in the bag. We're not going to go and rip out, they're not going to be opening the bag.
And I'm going to tell them that they can't do that, Ms. Massalone, so I understand your objection. It's definitely noted, but I disagree for this one.
Next one would be S-176.
No objection.
S-177. S-178.
So I think this, I mean, if we could reserve, I think the one of our objections is just, a lot of the firearms were shown to the jury. I understand the court made a ruling with respect to the weapons cache and how it's relevant. But any firearm that wasn't used or alleged to be used in this case, I don't know if that might confuse the issues, if we're admitting all of these guns into evidence, and firearm. So it was something that Mr. Murray and I wanted to confer about further, because we were just, so maybe that's something we can reserve on.
Tell me what 178 is again. I'm reading it, but just remind me of what it was.
So, Judge, what it is that the gun was found in a case. It's a lock case under the defendant's wife's bed. It's a black case.
Oh, the one we saw a picture of it.
Everything was kept in the case except for the gun, because the gun was submitted to the lab. The gun is actually in it's in a gun box. It's one of the gun boxes that was shown to Lieutenant Catalona. And this case has everything else. It's got a knife. It's got a magazine. Got a box of 9mm cartridges.
Tell me how this one is relevant underneath the bed. That that it would be necessary for the jury to have it.
Well, I mean, he's got guns in that bedroom. He's got guns in the bedroom that's his own.
I'm not disagreeing. He didn't have guns all over his house. What I'm saying is, I'm asking you just so the record is clear. Why?
Yeah, Judge, obviously he's got access to guns that are in more than one place in this house. One's in a gun locker. The gun safe didn't have the guns in it. He's got one in the bedroom, in his bedroom in the drawer with the laser sight in it. And then he's got this one underneath his wife's bed. I mean, obviously it's been testified to. It's been ruled admissible by the court previously, so I'm not sure I understand the objection.
Okay. All right. I'll give Ms. Massalone the weekend to take a look at it. If there's something she wants to submit on this particular one. I did rule on this as a pretrial issue, that I was going to allow this to come in for this limited purpose, which is located in the jury charge. But we can give Ms. Massalone the weekend to take a look at it. Next.
S-179, that was actually the gun that was in that piece. I don't know if it's the same issue that Mr. Decker just talked about. It was
The actual gun.
yes.
Is there there's no objection to that, is there? Or is there objection to that one too?
The actual gun that belongs in the case, or?
The gun was found in the case. The only reason it's not in the case now
She
is
sent
because
it
I
out
haven't
to
got
the
it.
lab, right?
Right, so it's not the gun, like the gun that's alleged to have been
Right.
used.
Correct.
So I think our objection is really just, again, the purpose of the weapon cache, I think, has been sufficiently established, and the jury had the opportunity to not only hear the testimony about all the weapons in and around Mr. Caneiro's home, which obviously it's out there, we're not, it is what it is, and on top of that, they got to actually see numerous weapons from the witness stand. So the objection is really just as to the prejudicial nature of them having the physical guns. I mean, it's one thing to hear testimony, it's another thing to hear facts and to see them. It's another thing to have access. Like, if they wanted to see the guns, they can just, see them all. I mean, it seems...
Well, they actually can't see any of them because none of them are allowed back in the room. They're just in evidence, so to speak, but they will never leave the state's possession unless for some reason they wanted to see it. If they wanted to see the cache of guns, they would have to come out here. We would have to all be a part of it, including Mr. Caneiro. And I would, if they did ask that, I'm telling everybody straight, is that I would remind them of what they could use that for and what they couldn't use it for. So it's really more of like, it's an exercise, and we're saying that it's in evidence, but it's really not going in there for them to have any.
Of course, Judge. I obviously understand that, but that's what I meant. I meant, like, if they wanted to see the guns, they could see them, right? And why do they need to see them again? If I don't think that I think it would be prejudicial for the jury to have, when I say access to them, I don't mean that they're stacked in there with them. I mean, like, if they wanted to see them again, I think the point of the weapon cache has been established. I think the means and opportunity that the state wanted to establish has been established, and just the idea of the jury being able to say, we want to see those guns again, we want to see all of them, we want to look at them, we want to examine them or see them in the courtroom. That's, at that point, I think we're going astray of what, the evidence in this, what the relevant evidence in this case truly is.
But is this something that you wanted to reserve on, or do you want me to rule right now?
If Your Honor wants to rule now, that's fine. I mean, that's our position.
Okay, and I respect your position. Under the circumstances, because we're giving that limiting instruction, I have, while I understand the argument, I respect the argument by the defense, I don't have the same concerns. The reason why that I would find that this to be relevant is if for some reason the jury is trying to understand the defendant's ability to understand how to use guns, even though there's testimony about it, if there was something about some of the other weapons that to show more familiarity for one of the jurors, I have no problem with them being able to see them. They're not going to be allowed to touch them or anything else, and it would be, like I said, it would be an open court. So I'm going to allow S-179. I will stay reserved, though, on 178, on whether that's necessary or not. But for 179, I do not have a problem with it based upon what I've said in the previous ruling and what I said here today. And just so that it's clear, on this final exhibit list, that was shown on January 22nd also. Okay. That's okay. It's okay. Next one.
S-180. objection.
Okay.
S-181.
So anything that was like another firearm, it's just the same objection. So.
And they're all noted for the record, and my reason is the same for each one of those, so, but I get your objection, and it is noted for any firearm other than the alleged firearm used in this case. There will be a standing objection for the defense. I respect that. I'm overruling that objection. I'm going to allow them. Go ahead.
S-182.
No. No objection.
S-183.
Well, so just to clarify, I mean, so sorry. I guess like one.
182 doesn't need to go in.
180.
Judge, I'm sorry, just for purpose of clarification, we can leave S-182 out, that's just the box. S-183 is the actual target. That's my fault for not identifying that.
Okay, so it's just 183 you're looking for.
Yes, I think that's really the evidence.
Are we on 183?
Yeah.
Okay, no objection.
Okay, next.
S-184.
No objection.
S-185.
No objection.
S-186.
No objection.
S-187.
187, 188 are just the same.
Same objection, and noted for the record, but they will be in evidence. Go ahead.
S-189.
189 through. Okay, so just to speed it up, 189 through 192, same objection.
All right, they'll all be in evidence.
S-193.
S-193 is the gun, so that's the alleged gun. No objection to that
Okay.
one.
S-194.
No objection.
S-195.
No objection.
S-196.
No objection. No objection.
S-222.
Same objection, small plastic bin with 6 magazines and 11 unfinished blowers. Same objection, just.
Tell me about this one, Ms. Wallace or Mr. Decker.
Yeah, Judge, I believe, I have to look at it, but I don't even know that we even opened this up. I obviously, as the court can see and as the court knows, if you go forward and back, there was a lot of items that I chose not to actually identify and not to actually display, including the rifles and the Uzis and the, thousands of ammunition. I used the one as a sample. I think this was another one that was just to represent as an example, but I can look at that in our vault downstairs just to.
Take a look at it. Let us know if that's an issue. If there is an issue, if you do still want to move it, just let the defense know, and then we can argue that. So I'm going to reserve on that one for now. Next.
S-225.
So S-225 and S-226, we had an objection to relevance and prejudicial. It's the bulletproof vest, I believe, was shown to the jury, but it's just there's no relevance here. It's not alleged to have been used. It's just in the basement, something that was found. And similarly, the bin with old spare cell phones. There's no relevant. I don't know what the relevance is. So I would object.
I hear you.
Judge, the relevance on 226 is the old phones. There was discussion about how the defendant left his phone home, and so the FLIR, only works in a phone. But there are these spare phones that were found.
There's no evidence to support that they were actually used. But is there? That these cell phones were actually used by the...
No, I was going to say not specifically, but I mean, that was an argument that his phone was home. There are all these other spare phones.
Okay. I'm not going to allow either one of those in. That you guys can argue that, but I don't find that they need the physical items of the vest and or the cell phone, so I'm not going to allow them physically into evidence.
The next one, Judge, is S-230.
No objection.
And then S 231, it would be A through E.
No objection.
S 232,
No objection.
and then S 233, 234, 235, 236,
No objection.
237, 238, 239, 240,
objection.
and 241,
No objection.
242,
No objection.
and I don't think we showed 243, so not 243. The next one is S 253. No,
Are you doing 244?
254. Are we not? I'm sorry, Judge.
Did you say 244?
You marked it on our thing.
I don't have 244 as being shown.
And I guess the next one, I'm sorry, not 253. It would be S 256.
No objection.
Okay.
S 261, and then there's a 261.1.
No objection.
S 262, and there's also a 262.1.
No objection.
S 263, all of the A through, it looks like M, and then 263, B through M.
No objection.
All of that is in. Okay.
S 264,
No objection.
S 270 and 270.1.
No objection.
S 271A through F, and then 271A.1 and 271C.1.
No objection.
S 272,
No objection.
S 273,
No objection.
and S 274.
No objection.
S 285, A and B.
No objection.
And then there's 285.1 and .2. Next ones, I think we'll withdraw because those are all, unless there's going to be an argument about contamination or something like that, those are all chain of custody evidence receipts. So starting on 286.
No, there's correct. No argument about that.
Okay. So then I would not allow 286 through 289 and 291.
And actually, Judge in 293, 94.
Yeah, you're right. You're right. Yep. I got you all the way through to 296.
The next one would be S 299,
No objection.
S 300,
No objection.
301,
No objection.
302,
No objection.
303, 304, 305.
No objection. No objection to any of that.
Is there any objection on between 306 through 316? All of the, because this is all the stuff that they just went through. And what about on the next page, 317 to 329?
328. No objection.
Okay, yeah, mine says 329, but if it's 328, that's fine.
We have 329 on the next page.
Okay.
But we don't have an objection to that here.
So it looks like 329 all the way to 338. Are we good on all of those?
Yes.
Those are all the stains and everything. Okay.
S 347, just trying to go down the line, sorry. Yeah, S 375.
Wait, I'm sorry, what?
S 375. The rest, I think they were all either reports
Property
or...
receipts or lab reports or whatever. Yeah.
375?
Yeah.
No objection.
S 391. S 392, it would be A, E, and H were the ones that were played.
No objection.
So just those three.
Yes, those are the only ones played. Next one would be S405,
No objection.
407,
No objection.
S418,
No objection.
419,
No objection.
S437, thank you, 467,
No objection.
S474,
We weren't sure what that is. Is that?
that was the timeline, Judge said, but it was a defense exhibit and then we wrote on it as well.
Oh, yeah.
Not great handwriting.
Got a little crazy.
You guys were having a party with that exhibit.
No objection.
Okay.
I mean, S477 was the DNA worksheet with the reference samples. I don't know.
I mean, I know we're having expert testimony coming too,
So I don't know what.
defense plans I'm using.
477.
Yes.
Can you put that on the screen, 477?
Judge, we didn't have an objection to that.
I guess if we're not putting in reports though, we probably wouldn't need it from DNA.
You want to, as it relates to some of this stuff, if something becomes relevant as a result of the expert on Monday, you can let me know.
Sure.
But I want to stay consistent that reports are not coming in. It's just the testimony as it relates to that. But if that becomes relevant, you can let me know.
We don't have, like, so there were two exhibits a few exhibits that we had that were marked up.
Right.
The state did not have an objection to. It was like an allele table.
Right. I don't have a problem with those. I know what you're talking about.
And the two deconvolution reports. So I don't know if if the state had something similar, we wouldn't have an objection. We just had an objection to like each and every DNA report that they originally, I think, were.
All right, let's do I know you want to argue the other part for the D exhibits. I don't want to do that right now. But as it relates to, for purposes of what you did on cross, as you highlighted that the results page, I don't have a problem with that because I think that would be demonstrative and helpful to the jury, however they want to use that. So that I would make as an exception to the ultimate reports. But I'm not sure about the deconvolution report. We can talk about that in a minute. But Ms. Wallace, you're looking like I'm saying something wrong.
No, Judge, it wasn't what I was thinking about. The
Oh,
next
okay.
exhibit on the list is an electropharogram, which I don't think that that's going to become relevant.
Well,
I know Mr.
why don't we
Marchese-
wait on that? Because I'm not going to rule on that
Okay,
until I hear from Reich. Right?
understood.
Yeah, I think in general, Judge, though, the electropharograms and the wheel charts and things like that, we're not going to have an objection to that because we're going to be using so much of that, I'd imagine, during the.
If you guys all want it in on both sides, then I'll make an exception to the rule on this, or my rule, I should say, on this. If you guys want that, I'm okay. But I don't want you to assume though that that if we allow something like this in, I'm not sure about the deconvolution report, because I do remember that from the prior hearing. Remember a lot of testimony about it, so I have to take a look at that again. But if you don't have objection to these items, and for you to use what you've already used, I have no problem with that.
Yeah, I think we kind of anticipated that this was going to be something that was in front of the jury, and we don't have an objection on specifically talking about 478, 479, 480. We don't have an objection to those.
478, 479, and 480, you have no issue with it?
Judge, I think we should take a look at this stuff, because I think what we're doing here is like we're putting in potentially deconvolution reports just because someone like put a circle around it, but we're not giving them DNA results. So like the idea that it's just in a vacuum, I think we have to look at like what is relevant, because obviously no one's going to remember 460 septillion versus 4.1 octillion.
They're not?
I doubt they are. I think the idea is obviously there's certain pieces of evidence that are, obviously relevant and probative. But I think we'd have to look at this, because, like, I looked at Ms. Mastalone's stuff earlier, thinking that maybe they were going to get certain things. Now, obviously, that voting table, we obviously have no issue with it. I think we wanted to put it in too, and we can do that without putting in the whole report. But I think there should be at least some sort of summary of stuff like that.
All right, we're going to reserve on 476, 477, 478, 479, and we can come back, and 480, we can come back to it.
And that's fine with us, Judge. We're not trying to, we can also talk it out and see if we're on the same page with what the jury should have. Like, we're not trying to
I respect that.
suggest that our stuff should be in and their stuff shouldn't.
I respect that. Okay.
The rest up to, looks like up to 493 were either the DNA lab reports or there was one other DNA lab reports. So, I want to again lump those in with the discussions that we're going to have.
Yeah, we'll hold off on the DNA stuff until after the defense is concluded. And then, and out of fairness, I should say this to both sides, that if you don't move something right now, if something becomes relevant after today, obviously I'll revisit it. Sure. So I don't want you to think you're precluded in any way. I would never do that. So let's come back to the DNA.
That takes us all the way up to 501 is the only, I think the only non-DNA one that's left.
And that was from today. That was the photo of Mr. Caneiro and his daughter?
Yes.
So that we would object to, because I thought the witness didn't lay the foundation. He said he didn't know when it was taken. He said he couldn't say. He said he couldn't remember if that's what Paul Caneiro looked like at the time of November 2018. I think based on our sidebar conversation, my understanding was that if the witness was able to lay the foundation and I guess connect the relevance to the case, then the court was going to allow it. But it was never published because I think the witness wasn't able to do that.
Mr. Decker?
Well, obviously, Judge, we had to deal with what we had to deal with, because the part of that photo was also, I believe, her photos similar to that were also in the phone. Obviously, I know where I got the photo from, but I guess I'll defer to the court with respect to the testimony thus far in that regard.
So this is what I want to do. The one thing that I do want to, he did talk about how the age of the daughter, but I want to go, I don't remember exactly the context, so we're going to go back, we're going to listen to that. You guys feel free to do it also. That would be the only thing that may give it context to around the time frame, but I agree with Ms. Mastalone. Otherwise, he was non-committal as to the time frame of when the photo was taken. So let me just look at the testimony on that. We'll make a final decision on that.
Just to put it into context, I think my recollection of the testimony is he said she was in her early 20s. At the time of November 2018, Katie Caneiro, the older daughter, was 26.
Okay. All right. So, and that, yeah, I think you're right. That's the exact words that he used. So I'll just take a look at it one last time, and then I'll rule on that. Sure. All right, let's go to the defense exhibits. I'm working off of, on the defense exhibits, just the document that you gave me a couple, maybe a week or two ago. Is that the document we're working off of?
No, we have a much more updated version, Judge.
So as far as actual exhibits, we did publish several during the DNA.
Before we get started, can you send by way of email right now
Yes.
the updated exhibit list so I can print it out and have it in front of me?
Yes.
And send it to the state? We'll make a copy for the state so everybody has it.
Can I use the bathroom over
No.
there?
Go ahead, of course. You can go, no, better not go in the jury room. Anybody else need to use the lavatory? Everybody okay? You can go. You can show me right there. Yeah, I got you. Yep, I got you.
I wrote all over this, so sorry.
I'll tell you later.
Yeah. What did you eat? What is it?
We're going to stop at 5 and then we'll pick up Monday morning. I'm sure Mr. Decker has a game to get to.
Phil, maybe tomorrow.
Mr. Murray probably doesn't want to hit any traffic on the way home.
Whether I do or don't.
It's happening. How's it been for you? I forgot to ask lately, sorry.
No. I mean, it's actually not. The summer was worse. Significantly worse in general.
I'm sending it right now.
Sorry, thank you.
No, you're fine. We're waiting. Mr. Murray's just emailing us. While we're waiting for that to print out, let's go over to the, I said, Ms. Messalone, when you were out, that we're going to stop at 5, no matter what. So let's just, let's go over to the jury charge for a minute while we're getting the printout. There was a couple of things that I saw that I wanted to make sure that I told you about. And then we would make those corrections. All right, so jury charge, as it relates to, it's no issues with the general information, nature of indictment, presumption of innocence, burden of proof, reasonable doubt, function of court, judge's questioning, function of the jury, all of that is a model. Same with direct and circumstantial. but I wanted to confirm with you on the top of page 7, can I take out the highlights now, and it's just the Petrozzillo stipulation, right? That's the only one we're gonna have?
Yeah, I think that's the only one that needs to be read to the jury.
Okay, so I'm gonna cross out lines 1 through 3, but it has that in there. I'm gonna take the number 1 out of there, so it'll just say, during the testimony of Lieutenant Petrozzillo. That's the only thing it's gonna say in that paragraph for stipulations, and I'm not gonna just change it to stipulation. Credibility of witnesses, model, identification, fine. I wanted to go to my notes. Abraham was Abraham after Schlenker? Yeah, here he is. He is,
I think it was Monday, she was.
electrical and electromechanical engineer matters and cause and origin of fire and explosives was what he was accepted as an expert. So we'll add that in there, into that section. And I'm going to take out on line 24 where it says the defense called. That I don't think that's necessary. It should just say Carl Reich in the field of forensic DNA analysis, unless you want me to specifically say the defense. I just didn't want it to look like the state has all these and the defense has defense has one. I thought it would look cleaner if we just said it that way. But if
No, that's fine, Judge, yes.
okay, all right with that, so we'll fix that. Do that. Nothing on the narration. I think that's fine. Defendant's recorded phone conversations are fine. Limited instruction, certain evidence, fine. Witness prep is fine. Third-party guilt, page 15. Line 3, I'm just going to cross out, it says his/her. I'm just going to take out the her portion. And then on line 9, it just doesn't have a period at the end of it, so we're just going to put that in there. On page 16, lesser included offenses, line 4, that first line, I'm just going to change it to included instead of inclusive offenses. And I'm just going to change it to lesser included offense. Ms. Mastalone, for the record, I should say, Ms. Mastalone requested the court to consider a lesser included charge, a third-degree theft charge. And looking at the gradation, it was the court's position that the grading will be the amount of whatever they check in what box, so it's not really on a lesser included offense per se, it's just whatever number that they come up with, whatever range they come up with. So I was not going to make that a specific thing, because it's really depending on the money, and I didn't want to confuse them as to different money would have a different level of crime. I just wanted to make it generic. You tell us what range that you're finding, if you find him guilty at all. So that was the reason why that I didn't think that was necessary, but I wanted to give you the opportunity, considering you put it into an email, if you wanted to put something on the record. If you think I'm wrong, you can. Go ahead.
Just have one moment, Judge.
Sure, of course. Here's the model charge. So
for?
Actually, we're just looking for the verdict sheet to see how it matches the.
Oh, the verdict sheet? Okay. I have that up here too, if you don't have it. Yeah, as soon as I can find it. It's here somewhere. I had it on my right. Here we go. Let me just get to it for everybody. So it starts with question 13. It's right there on the bottom.
Okay, yeah, that's fine, Judge. We, at the time that we sent the email, we weren't looking, we didn't have the verdict sheet. We were just looking at the charge.
Okay.
So that makes, I see how it corresponds. Thank you.
Okay, sure. All right. So we'll leave it that way. All right, so that's that. We'll just fix that, clean that up. Like I said, with the murder charge, after I read it, then I'll give them the verdict sheet and we'll go through it line by line to make sure that they don't have an issue. I want to go to the felony murder. If we can go to page 25 at the bottom. Is everybody there?
In the jury charge, Judge?
Yeah, and the jury charge. Line 29 starts with number 1, that on or about November 20th, 2018. You see that?
Yes.
All right. So if we just continue on, the defendant was engaged in the commission of or attempt to commit or flight after committing or attempting to commit the crime of arson. And then it says, as charged in count 7, but that's not accurate. It should say, as noted as a lesser included offense to count 7. Because they're not alleging in the felony murder aggravated manslaughter, which is count 7. It's only arson. So with that being the case, I have to clear that up. So that's the way I was going to say it. So it would say, instead of charged in count 7 of the indictment, it will say, as noted as a lesser included offense to count 7. And then I still lay out the elements of arson when we get down, starting on line 10 of that same charge. And if you look at number 1, which is on line 12, it should not say, it says that the defendant purposely started a fire, and it says on his own property at 15 Willowbrook. It should not say on his own property. It should say started a fire at 15 Willowbrook Road in Colts Neck, New Jersey. Does anyone disagree with those 2 changes?
No, Judge, we don't.
The second one, no, Judge. The first one, I'm sorry, I didn't quite follow.
Okay, so count 7 of the indictment charges the defendant with aggravated arson. Same thing with count 8. When you look at what the felony murder indictment, when the state does the indictment, it's saying that these crimes occurred in the flight after committing or attempting to commit the crime of arson, not aggravated arson. So they don't have to prove aggravated arson for it to be a felony murder. They have to prove arson. So that's not the actual charge in count 7. It's actually the lesser included of count 7. So that's why that I'm saying that it's the lesser included charge, so they don't get confused of going to count 7 and looking at aggravated arson, because that's not what they're saying in the indictment. That's not the allegation. That makes sense?
Does.
You can look at it. Take your time. The next one that I observed was the page 31. It's a minor edit. It's just should say lesser included offense. It's not offenses because it's just a one for arson.
Can I make a suggestion?
Yeah, of course.
I'm sorry. I think maybe it could just say commit the crime of aggravated arson or arson.
Where?
In what we were just talking about, the
Felony murder?
yes.
They didn't present aggravated arson to the grand jury, so he's not. That would not be what the grand jurors decided probable cause for, is aggravated arson or arson for that count. They only found the arson for that count. If you want to think about it over the weekend, Ms. Maslone, I don't want to force you. You can look at it.
Sure, Judge. Yeah, my concern was just that I didn't want to confuse the issues if they were to find Mr. Caneiro guilty of only an arson, that they were under some misimpression that, that's when they would find him guilty of the felony murder. So I just wanted to.
But that is true, though. If they found him guilty of just arson, that would be enough for that element of felony murder.
Right, I understand that, and okay, that's fine, Judge. Yeah, we'll talk it over and just.
Yeah, digest it over the weekend, but that's the way I read the indictment. Am I wrong, prosecutors?
No, you're not wrong, Judge.
Okay, so you guys can let me know. But that's, as of right now, that's the way I read it. Count 9, we're dealing with possession of a firearm, It's on page 33. I had information, more testimony before I made the decision on whether there was some evidence to support the possession of a weapon for unlawful purpose against Jesse Caneiro and Sophia Caneiro. Ms. Maslone, I'll give you a chance to argue it. I'll tell you so that you know what I remember of the testimony so that you can address it if you'd like. Or Mr. Murray, I apologize. Mr. Murray, if you want to respond. I do find, based upon the medical examiner's testimony, that because one of Jesse's injuries could have been from a gunshot wound, that I do not have an issue with including him. As it relates to Sophia Caneiro, based on the fact of the testimony, if you put all the testimony together, that Sophia's blood and Jesse's blood were found in the kitchen area, that and the shell casing was found. Was it the shell casing of projectile in the kitchen area? Projectile was found in the kitchen area. That I do not have an issue with leaving Sophia Caneiro in because it's an and or, so it only needs to be one of them. And obviously, Keith Caneiro suffered multiple gunshot injuries, and Jennifer Caneiro suffered a multiple gunshot injury. So that would be my position. So I'll give you a chance to argue against that if you disagree with me, but that's what I recollect from the testimony.
Judge, when we submitted our corresponding comments for the previous draft, we just said we defer to the court.
Okay, all right, so as long as we're fine, then I'm going to allow that. And we're going to just take out that highlight, which will then take out the highlight on page 36, line 7. I want to go to count 10. The court.
Judge, I don't know if it makes your life easier, but we did intend, before we rested and kind of forgot, to dismiss count 10.
Okay, so count 10 will be dismissed. So that will be taken out of the charge. So that's page 36, 37, 38, up to line 19. Okay. So now we're talking about the knife on count 11. Line 20, we have to add in the exhibit number, which we've already mentioned is 313. Am I correct, state that that's the exhibit? Because that's what we originally talked about in line 14. That's 313.
I believe that is the number.
It is, yes.
Okay. That was the only thing that I saw as it related to that particular count. Is the state still continuing with the unlawful possession of the knife on count 12? Or, I don't care, I'm just asking because of what you said about count 10. It doesn't matter to me, I'm just...
Which I think we are going to keep that one on the indictment.
Okay, that's fine. So with that being said, I didn't have anything else to add as to that count or any of the anything there. And just to move it along, I don't have any issues through the end of it because it goes through the theft charges, the hindering charges. I didn't see anything. I'll scour it one more time over the weekend. I'm sure you guys will do that also. The last issue as it relates to the charge, and then we'll get to the last proposal by the defense, deals with the addition that was made by the defense as to what happened in sidebar or what happened in open court. The defense asked for something to be added. Obviously, it's within the draft. It has been marked. This draft has been marked so that the proposal will be on the record in its entirety as to what was requested. I don't disagree. I don't agree with what all the things that are in here. What I would do, Ms. Mastellone, is I will tell you this, that when I do the beginning part of the charge and I talk about objections, I will remind them again of what I reminded them of early on in the trial to deal with the fact that any communication between counsel, between me and counsel, or anything that happened in sidebar must not be considered for any reason, for any purpose. But I don't see myself reading your specific request. But if you'd like to put something on the record, you can. But I will expand a little bit as it relates to that issue right under function of the court on page 3 at the bottom when it talks about sustaining objections and ruling on admissibility of evidence. I will talk about it a little bit there. But I don't see the need to put all of that in writing because I don't think that should be something that should be highlighted. But go ahead. If you want to put anything else other than what's already there.
Judge, just that originally the draft that the court provided to us at the very end of it had the word sidebar bolded. So I thought that the court was asking us to propose a charge. That's why my comment said...
I'm sorry. The sidebar was, I bring you guys to sidebar to see if there's anything that I missed in the charge. That's what I meant by sidebar. It wasn't for something to be added there. I apologize.
Okay, yeah, my original comment said, is the court seeking an instruction on sidebar? If so, this is what I would propose.
Okay.
And what I proposed was, I thought, relatively neutral. I think, given the unique structure of this courtroom, I don't know, the jury is very close to the bench, and I know that, there were a lot of sidebars in this case. So the instruction, I know the court's indicating it's
going to be part of the record, if I could just read it briefly. During the course of this trial, there were numerous occasions during which the court conferred with the attorneys at sidebar. The conversations are a normal and necessary part of trials and are designed to address various legal, procedural, and evidentiary issues that arise during the trial. You must not speculate about the subject matter at any sidebar conference, nor should you draw any inference or conclusion from the fact that a sidebar occurred. Neither should my rulings that result from these conferences be taken as favoring one side or the other. Additionally, you must not consider or evaluate the demeanor, tone, or manner of the court or the attorneys during sidebar conferences for any purpose. Judicial rulings, comments, or demeanor during legal discussions are not evidence and are not an indication of how the court views the attorneys, the facts of the case, the credibility of any witness, or the guilt or innocence of the defendant. It is also important to note that attorneys in this case are tasked with providing zealous advocacy, which includes raising objections, making legal arguments, and addressing issues at sidebar to ensure that the trial is conducted fairly and in accordance with law. I think the last paragraph is a little bit redundant, but so I'll skip over the last paragraph, which basically just says ultimately the verdict must be based solely on the evidence and not on anything observed at sidebar. I thought it up because I thought that the court was asking for a proposal, and then as I was thinking it through, I just thought maybe, again, I was assuming that the reason why we perhaps wanted it was because there was a lot of sidebars and because there was a lot of interactions. And even today, I know the court excused the jury momentarily while we had like a sidebar because there was a concern, like, are they paying attention? Are they looking? Can they hear anything? So that's why it was proposed.
Mr. Decker or Ms. Wallace, do you have an issue with the first two paragraphs? I would move it up to under the function of the jury. I'd weave it in there. Function of the court, sorry, on page 3. If you don't have a problem with it because of where we are, I can read that in. I don't like to highlight certain things because I don't want them to say, well, they're telling us not to, and I wonder why. So that was my concern, but if the state doesn't care, then
I think I agree that I just don't know that you need to be adding, again, I've said it before, I don't know that you need to be ad-libbing into something that is generally within the function of the court as part of a model charge.
Okay. All right, let me think about it over the weekend. I plan on saying some of this so that everyone knows. It's rare. It is rare, but there are times that I'll go off script just to provide some, and what I feel is helpful information to illustrate something, but it's not that often that I do that. If that would have been something I would have done here just to make it clear to them. But let me think about it over the weekend. So before I just flat out say no, I will think about the first two paragraphs, Ms. Mastalone. I'm going to say, I think the third one is redundant. I agree. I'll take a look at it one more time, and we'll go from there. So the last thing, though, we'll do that, is the last request, which candidly I was confused by, is for the ballistics related charge. I do not see how any of this was either testified to or something that should get before the jury. This is not a model charge in any way, shape, or form. I'll read it. In this case, you heard the testimony of a witness, Christopher Clayton, who claimed special qualification in the field firearm tool mark analysis. And first of all, he was an expert, so he's not claiming anything. This witness has offered an opinion that bullets labeled 11, 12, 17, and 20 were identified by him as being fired from the Sig Sauer barrel marked as S-176. The witness also offered an opinion that the shell casings labeled 13, 14, 15, 16, 18, 19, and 21 were identified by him as having been discharged from the Sig Sauer pistol marked as 193. When evaluating this testimony, you should know that the method used in this case, AFT, E provides a broadly stated framework for conducting tool mark analysis. However, and then wants to cite to the President's Counsel advisory, which was not a part of this case at all. However, this framework is not specific enough to qualify as a validated method for this type of analysis. That's not testified to at all. You should know that the analyst employing this method must make subjective assessments through the process. He testified that they were subjective assessments, but I don't think that belongs in a charge. You should be aware that regardless of what preconceptions you may have about the infallibility of firearms and tool mark analysis, this method is not infallible, as errors can and do occur with any judgment-based method. And again, so citing to this advisory that none of this was not brought up by Mr. Murray on cross-examination, nor was it cited as it's in this charge. Any conclusion about the accuracy of the method must be based on what the empirical scientific evidence support, and not on the analyst's personal experience or degree of confidence in their own work. Any statement by either the witness or an attorney implying the infallibility of this method or a chance of error so remote as to be a practical impossibility is not scientifically valid. So you can argue it. I just put it on the record so you don't have to read it, but I don't see it. But go ahead. I want to give you the opportunity to argue what you want to say, and I'll hear from the state, and maybe you can change my mind.
Judge, yeah, so this one I did not personally draft. This is sort of an extension of the the pretrial hearing that was conducted with ballistics, and I think a lot of this was really argued pretrial. So with that in mind, my understanding is that this is a charge that is being requested in cases such as this, where there's like ballistic matching, and the purpose is to kind of educate the jury on the limitations as we see it, I guess. So the charge is not, I'm not the first person to ask for this charge. Right. I think it's been requested in other cases. I don't know whether it's been ultimately given. I could ascertain that information if the court wanted to know. But I think given, again, just the context of the pretrial litigation, or within that context, is the court denied the motion, right? So our next request would be like this mitigating measure with respect to the charge.
Okay, I understand. Mr. Decker?
I mean, just very briefly, it's just nowhere near supported by any testimony from Sergeant Clayton, be it direct or cross-examination. We're citing to the PCAST. If Your Honor would have given this charge to yourself over the summer, that might have been appropriate, in the sense of like that's where the testimony about this type of stuff was, but not in front of this jury.
Yeah, I understand and it will be a noted objection on the record. The court rendered its decision as it relates to this ballistics expert testimony. I allowed it in despite strenuous objection by the defense. This is something that a reviewing court, if the defendant is convicted of anything here, would be able to review. I do not find under these circumstances that anything within here was really testified to. Mr. Sergeant Clayton was not confronted with the PCAST report, or was any of this really discussed. So I'm not going to allow this charge, but it will be kept preserved for the record. What I'm going to do is, if you don't mind, let's make sure that we mark this charge that was requested firearm and tool mark evidence, so that the record has it for Ms. Mastalone for any future event. What C exhibit are we on right now? Do you know? Actually, it should not be a C exhibit. It should be a D exhibit.
Hang on.
It should be a D exhibit. So let's mark that as. You stop at 122, Mr. Murray?
45, I think, is their next number from the list we got.
I'm sorry. In terms of our exhibits, we're at D145.
I only have up to 122.
You have
Maybe it's on a different page.
You should have it up to 143 because that was shown by Ms. Mascalone during the annual Reed presentation.
Oh, okay. So this would be D145. And I'm going to mark D145 so that a reviewing court would have that.
Oh, okay. Thank you. I'll add it to her.
Yeah, so let's add that. So we make sure that it's all in there for the future. Okay. So with that being said, anyone else have any other issues with the charge? Because what I'm going to do is, over the weekend, my clerks just learned that they have to work over the weekend, that over the weekend, we're going to send you back the final charge. And we'll have the watermark still on it saying final, but if you have some issue with it, you can let me know, and we'll talk about it on Monday. But make sure that you get that before Monday morning, and you have time to review it. Hopefully we can get it to you sometime tomorrow, so you can have it for Sunday to read while you're having appetizers for the Super Bowl. Anyway, let's go to the D exhibits. Mr. Murray, go ahead.
So, Judge, the first one that we published to the jury would be 55.
55, okay.
The group text with Ben, Keith, and Paul.
I think that was just that was a more complete version of what we had shown, so we don't have any issue.
Okay, so 55 is in evidence, or will be, I should say.
The Canada Life full payment history was D64.
No issue.
Okay.
D71 was the, a portion of the Merino body-worn camera starting at 3156.
We looked at all the photos. I didn't have any issue. We didn't have any issue with any of the photos. I just didn't. Is that included in the stack of photos?
That's a body-worn camera.
This is a body-worn camera. It's another part of it.
But we have,
Is it a screenshot?
no, we had played some, remember, so we played some, it was
Yeah.
already published to the jury,
Yeah.
but we didn't have an opportunity to confer with the state on that. I mean, I can provide them with the videos over the weekend and they can take a quick look, but it's all stuff that was played to the jury.
No, that's fine. That's fine. No objection.
Okay. Yeah, I don't see the issue. If it's already been played, it's a body-worn camera. All right, so D71 is good.
71.
You said, I thought you said 71.
Yes, D71.
Yeah, that's good. You're
Okay.
good with that.
All right, and then D71.1 screenshot photo of the refrigerator.
No issue.
Okay. And
And then the next exhibit would be 106.
the other body-worn camera for Redmond.
No objection.
Okay. And again, so everyone is clear, body-worn cameras, if they want to see it, the jury wants to see it, they're going to have to come back out here. We have to play it out here in open court. Mr. Caneiro, you'll be here if they want to see something like that, okay?
So then D114 would be the video of 44 Willowbrook from 2:46 a.m.
Isn't it already in, or no?
I think it was no, because it was a separate video, that exhibit that we had played at 20:34:10.
Oh, this was much earlier.
Right.
Okay.
This was the other. I'm sorry. So the timestamp should be 20:34:10.
Yeah, 8 o'clock at night.
Yep. Right.
No objection.
All right, so that's it.
There was the email that was published to the jury, D122.
It says email between Paul Caneiro and Sense.
Sense is the company that he was corresponding with in that email.
Oh, yeah, I remember.
To Detective Magrisi.
I remember.
Yeah.
Yeah, there's no issue. We didn't object then.
Okay. That's it?
The remainder of the, no, yes, they are. So starting at D137.
Okay. Let's hold the DNA stuff until Reich is done.
Right, so the rest is DNA.
All right, so let's talk about the photos. You guys have looked through those, or do you still need more time, Mr. Decker?
The defense photos?
Yeah.
We have no issue with the photos. I mean, they're getting a lot of redundant photos like we've talked about, I think, but we don't have
want
any
to do.
issue. Yeah, but we don't have any issue with any of the photos.
Okay.
There's nothing wrong with it.
If you guys want redundant photos in there, I'll do it. I just think we're confusing them by doing that. But if you guys want your own exhibits in, I have no problem with it. So if you want them in, do you know which ones you want to put in?
We have it, so we have the full list. I think what would be probably most helpful for the court, I would imagine, is if I go through that tonight and take out the places, the photos we're not using,
Okay.
the ones we didn't show, so you can just have a list of everything that's in.
Perfect. You can do that, and just have me, if you can send it to us in a PDF over the weekend, we'll look at it,
Okay.
and to the state, and as long as there's no issues, then we'll be fine with that. And you figure out, Mr. Murray and Ms. Mastellone, but you guys figure out how you want to give that to the jury. I don't care. That's up to you guys.
Our intention is to just give them the photos.
That's
That's why
fine.
we printed them. But also, if the court, we could do like a one-sentence instruction and just say, you may notice that some of the state's photos and some of the defense's photos are duplicative. That's...
Somewhere in the charge?
Yeah, I think that's fine. Like, just to avoid any confusion as to why they may see, like, you may observe the same photo twice. It's because both the defense and the state submitted the same photo.
That's a good point. I can do that. That's not a problem. I'll do that. Okay. Anything else as it relates to the evidence? How about the verdict sheet? Did you guys have a chance? Did you say you didn't have a copy, or you just didn't have one handy at the time?
We have one.
We didn't have one handy at the time that we were looking at the...
Okay. So does anybody have any issue with the way that this is laid out, or how? I think we've gone over this a few times, but I just want one last chance.
No issues.
Okay. No?
Just judge.
But if something happens over the weekend, just shoot us an email over the weekend so we can clean it up, and we'll do that. Okay. Anything else that we need to discuss right now, or does everyone think we're good?
I can't think of anything, Judge.
Okay. From the defense?
Thank you.
Okay. All right, so we are concluded for today. Monday morning, we'll be back here at 8 o'clock, and we'll start with testimony at 8:30. Everybody have a nice weekend. Please be safe.
Good, Judge.